Draw straws as to who
Well,
goes first?
I'm sorry, I was told by Ms. Kenworthy-Lewis that I would go first, and according to the 27.1 rule, I do, but I serve at your pleasure. Who would you like to hear from first?
Hadn't thought about it.
Always flip a coin.
Although I was the appellee in the appeals court, I was the petitioner on the further appellate review application. And so under 27.1, unless the court orders otherwise, I believe I'm supposed to go first.
Well, why don't we do that? Any problem with that?
No, I was just told by Ms. Mullen I was going to go first, that's why I sat over here, but
Okay.
Well, somebody's got to go first.
I don't think anybody will mistake me for the Commonwealth, so it doesn't matter where I sit. May it please the court, I'm Jane Lerman-White. I appear today on behalf of John Gray. I'm mindful that this is a 10-minute argument, and I'll get right to the point. The focus on what was ordered by the major of the state troopers was the subject of the motion to suppress hearing. Specifically, each witness was asked what was the authorization and the protocol ordered by Major Baxter for this hearing. Consistently, that was TR 15. Although a different protocol, which had been subsequently promulgated, was referenced and was in a packet of evidence submitted as Exhibit 1, that packet was specifically addressed in cross-examination, both by the defense attorney and in questions specifically targeting that by the motion judge. At the end of the hearing, this was, again, the subject of the judge's inquiry of defense counsel. At TR2, page 20, the judge asked the defense attorney, in the packet that was admitted into evidence on the last date, one of the things that was submitted was Order 10 DFS 35. Was there any testimony from your recollection from any of the officers that was given to the troopers? The defense attorney responded, there was not. In fact, those questions were asked directly to those officers. The screening officer and the other two officers that testified made it very clear that the only order that they read or were trained on was the TRF 15 guideline. The 10 DFS piece of paper was not read, was not trained on, was not part of the training. It's not included in the directive from Major Baxter. And the 10 DFS 35 predates Major Baxter's order. So if he had wanted to include it and reference that and incorporated it, he could have done so. He did not do so. The defense attorney continued, I did ask those questions on the last date for that reason, and it was not included in the training. Subsequently, the judge asked the assistant district attorney about that very thing. And he says, my problem I'm having is that the DSF order amplifies what TRF 15 allows, but I didn't hear any testimony. I agree with the defense counsel's statement. They specifically said they didn't read that or were instructed to read that before they went and did the checkpoint. The assistant district attorney responded, not that there had been a testimony, not that there had been incorporation, not that it governed the hearing, but that in fact it didn't matter because he said the screening officer asked every motorist the same questions. And because he asked the same questions, there wasn't an abuse of discretion. He said, I'd suggest that he asked the defendant the same thing that he asked all the other motorists. And as a result, it was fairly asked of the defendant. The judge below, instead of ruling on the protocol, took the Commonwealth, which was obligated to uphold what was done here as a warrantless search, took the Commonwealth's version of events and said, if taking this, which as it turns out was a mistaken recollection of the evidence on the point, but the judge met the Commonwealth on what it was arguing and said he wasn't, the fact that he asked all the motorists was not authorized under even under the DSF 35 because he could not ask the questions without reasonable suspicion. The Commonwealth then did a motion for reconsideration, and its version of events now was that the testimony was that the officer asked all of the motorists first where they were coming from, and only then, if there were reasonable suspicion after getting in the person's face and smelling alcohol or whatever, that at that point there was reasonable suspicion. And so the officer was entitled to ask the defendant the further question.
But you're saying that original testimony was not that?
The original testimony, as it turns out, from the screening officer was that he had reasonable suspicion beforehand, and therefore he said he saw glassy eyes and that he smelled alcohol.
So he didn't testify that he asked those same questions about how much, did you have anything to drink, blah, 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 of everybody?
I think that he testified, I believe that the testimony was that he asked that of everybody that he had, quote, reasonable suspicion of.
Oh.
But the district attorney's response was more global in that he asked it of everyone. And obviously, none of the parties had the transcript at the time of that argument, or at the time of the ruling, or at the time that the Commonwealth, again, misrepresented the evidence in the motion for reconsideration. However, the real focus, as noted, and it was obvious to defense counsel, was what protocol was ordered to govern here. If it were the TRF-15 only, that upon reasonable suspicion, the screener was directed. The screener shall direct the motorist off-road to the pit where further interrogation or testing should be done. There wasn't an alternative of may chat with him further and ask questions seeking self-incrimination, but instead shall direct off-road. Because of the misapprehension and the mistakes made by the Commonwealth in recounting the testimony, I suppose the appeals court decided that this was the critical point, and this was, in fact, the argument made by the district attorney. Instead, the critical point was that which was recognized by the defense attorney and by the motion judge closer in time to the hearing. It was a question of which protocol was ordered by Major Baxter to govern, and it was TRF-15, and under that, there was no right of the screening officer to ask any questions, whether before reasonable suspicion or after. Instead, upon reasonable suspicion, he was to direct him off-road.
Now, the duty assignment sheet, which is RA 21,
Yes.
was that reference as to what that was and who was given to?
I believe that the duty assignment sheet was what was passed out right before the thing and talked about which roles the people would have. The screening officer was the one in the road. But specifically, there was no evidence that the DFS protocol was incorporated in Major Baxter's order. It's obvious that the Commonwealth has sought to parlay its inclusion in the packet to mean that it was incorporated, but this was the specific subject of questioning by the defense attorney below, and obviously, as I have read to this court, by the motion judge at the end of the hearing, specifically targeting both the defense attorney and the motion prosecutor about whether there was any incorporation, whether Major Baxter had included it, and he had not. There was no such evidence.
Is the problem simply that the TRF-15 requires, in order to send to the secondary screener, requires an articulable suspicion of being under the influence? But you're saying that's not, even though that was evident in this case, the fact that he kept speaking invalidates the whole thing. Is that what you're saying?
He testified that he had reasonable suspicion.
Right.
And that on the reasonable suspicion, he was entitled to further question.
Okay,
But in fact,
so we should have sent him to the secondary screener as opposed to asking him questions.
Yes.
And because of that, it invalidates everything.
it invalidates everything. I would call the court's attention, I think, to Commonwealth versus Murphy, which is terribly instructive in
I have read that.
in several ways. First of all, in Murphy, that was a challenge to the facial validity of the operations plan. And second of all, and this is not, this is obviously as applied in what occurred here and whether the protocol authorized what was done. Second, in Murphy, the TRF-15 was different. It was amended after Murphy in accord with a suggestion, frankly, in Murphy. TRF-15, as it existed in Murphy, said that upon reasonable suspicion, the screening officer may divert the driver off-road to the pit. That was changed, and as noted in my brief, the court should not take lightly the distinction and the change between may divert off-road and shall divert off-road.
Did divert off-road here.
He did, but only after questioning that the reasonable suspicion is what in TRF before said he may divert, and it was changed on reasonable suspicion, he shall divert under the TRF 15 protocol that exists and governed here in this case. Third, in Murphy, there was indeed attached a separate document from the TRF 15, which said that there could be questionings that he, quote, should refer off-road for questioning. One of the challenges made was that meant that it was required, but this was a facial challenge, and it left to a later date whether or not, as conducted in Murphy, it was an invalid procedure and suppression should be ordered. In fact, that in footnote 9 of Murphy, it's that anticipation of further litigation and that there indeed would be further litigation on as applied. And I suggest that in context that specifically means the questioning which occurred here on behalf of the screener. But I also point out that in Murphy, unlike here, there was a separate document that was incorporated into the operations plan. Unless the court has any further questions, I'll end.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Michelle King, Assistant District Attorney for the Commonwealth. This is the Commonwealth's appeal of a granted motion to suppress by the lower court, and the appeals court reversed that, finding that the motion judge had erred by finding that, as a matter of course, the initial screening officer asked each driver whether or not they had been consuming alcohol before viewing an articulable sign of intoxication. That was completely contrary to the testimony of Trooper Dettell in this case, where he testified that only after viewing articulable signs of intoxication, specifically in this case, glassy eyes by the defendant and the smell of alcohol coming from him, that then and only then did he ask the driver whether or not he had been consuming alcohol. So the appeals court found, and as this court should find, that the finding by the motion judge that, as a matter of course, the trooper asked that question beforehand is clearly erroneous. The motion judge then used that clearly erroneous finding to base its conclusion that, as a matter of course, again, the trooper's actions did not comply with either TRF 15, the Trumbull guidelines, or 10 DFS 35. This court need not go any further to reverse the motion judge's findings than finding that the conclusions of law made by the motion judge were erroneous based on the erroneous facts that he found. To the extent that this court does want to address the broader issue of whether or not 10 DFS 35 was in fact included in the plan, I would suggest to you that there was ample evidence within the record that 10 DFS 35 was in fact part of the operational plan for this roadblock.
But I think Ms. White says that there was contrary evidence, that it was specifically not trained on and not mentioned, and so that the actual officers who were conducting this were not ever made aware of it.
That's her contention, Your Honor, and I can certainly point to you, and I will point to you where that's contrary. First off, just to back up 1 minute, aside from the training question, the motion judge clearly thought that 10 DFS 35 was part of this operational plan because he specifically addressed it in one of his conclusions, in one of his findings of fact. In fact, he cited to 10 DFS 35 specifically in paragraph 3 of his findings of fact.
Perhaps he was mistaken again.
Well, perhaps he was, but that was the finding that was a finding that he made. He cited 10 DFS 35, and I'll go again and I'll tell you some other parts of the record where it's included. He also cited it in his conclusions of law. So if he thought that 10 DFS 35 was not part of the operations plan, certainly he would have made a finding in that regard, or he would not have included it within his findings of fact and his conclusions of law. Now, if you look at the testimony from Detective Captain Hughes, he was asked about a packet that was eventually admitted as exhibit number 1, and the prosecutor asked him some questions. He said, "And I'll show you a packet which I believe your office provided. If you could take a moment and look at that, I'll ask you some questions. Detective Captain Hughes says, I'm familiar with it. The prosecutor says, is this the packet of information, internal memos, policies, as well as notes and media outlet information from this particular operation? And Hughes says, yes, this packet basically contains all of the administrative paperwork necessary to conduct a sobriety checkpoint. There was no objection by the defense counsel to that coming in. Now, if you look at the letter from the commander that talks about what guidelines,
Wasn't some of that data compiled after the checkpoint?
pardon me?
Wasn't some of the data in that packet compiled after the checkpoint took place?
Absolutely, yes.
So how is it pertinent to what was governing the checkpoint prior to its having happened?
He does talk about that a little bit, Your Honor. He talks about the various components. If you read further in the transcript, he talks about the components of what things are included in that packet, and he does say that some of the things included in the packet that were submitted are in fact things that are used for statistical purposes only afterward. But he's asked specifically about the commander's letter and that it only said TRF 15, but what it also said was, it says TRF 15 and additional written operation plan. And that's the key operative here, because there were a number of things that were used as part of the operational plan for this particular roadblock that were not specifically listed in this commander's letter. For example, the duty assignment sheet that everybody was talking about that portions of were gone over during the training. The duty assignment sheet was not specifically listed in the commander's letter, yet it was part of the written operational plan. And I would suggest to you that although it was not specifically listed in the initial letter from the commander, it was part of the written operational plan. And the case,
You say that, but Captain Hughes testified that he didn't even read it in preparation for this checkpoint, that he knew that it had come out a while ago, but he didn't even read it
You mean
when he did the checkpoint.
The DSF 35?
The 10
whatever it is.
DFS 35.
correct, Your Honor. And I would suggest to you that the constitutional requirements for roadblocks have never micromanaged what the troopers are supposed to read to each other. What is required is that there is a written plan, and a written plan is strictly followed. And I would suggest to you, and if you look at Murphy talks about a number of other documents that are referenced in addition to TRF 15. And even Murphy says, while it would be more clear that some of these mandates were included in TRF 15, what's important is if you look at all of the documents, and in Murphy it included the division commander's letter, and it included TRF 15, that if it's under this written plan, then as long as it's strictly complied with, then that follows the constitutional mandate. And here, Trooper Dittel specifically testified that he and other troopers were trained that if they view an articulable sign of intoxication, they are permitted to ask a follow-up question about consumption. Now, Detective Hughes testified that that the troopers were all made aware of this 10 DFS 35 when it was promulgated in 2010, that it may not have been read specifically to them that night. I would suggest to you it doesn't matter. What matters is there was a written plan. 10 DFS 35 was incorporated into that plan, and Detective Hughes was clear that it was incorporated, although not specifically listed, because he was asked several questions by the defense attorney.
Isn't that the problem? I mean, when we give the police the authority to do stops without suspicion, we say it has to be within the context of a very precise plan. There's no document here which makes reference to 10 DFS 35. It's not in the duty assignment sheet. You're basically saying it's incorporated by reference because they understood that it existed and therefore they would have understood that. But isn't that precisely what we're trying to avoid here constitutionally?
No, Your Honor. Respectfully, I have to disagree. If you look at the commander's letter, the commander's letter says this roadblock is to be conducted according to TRF 15 and any written operation plan that I have. Detective Hughes was very specific that 10 DFS 35 was part of this written operations plan. The troopers were trained specifically that they were allowed to ask a question about consumption if and only if they viewed an articulable sign of intoxication, and that is exactly what happened here. Trooper Dittel, testified that only after he viewed 2 articulable signs of intoxication did he ask a question about consumption. So there was a written operations plan.
Does the record reflect the written operations plan?
The packet that was submitted, Detective Hughes testified that that was the plan for this particular roadblock.
Plan was a packet of documents? That's the written operations plan?
Yes, Your Honor, and that's fairly commonly known by the troopers and the officers in charge who run this. They receive a packet of information from the commander along with the letter.
Be a written operations plan. So you're saying that that composite of writings constitutes the written operation plan?
Yes, Your Honor, and I would suggest to you that's what Murphy was talking about. It was
Murphy's quite, I wrote Murphy. It's
I
quite different. It's
understand you
quite
wrote-
different. There was actually a specific directive for this particular checkpoint. Here, the only one that I can see that may be analogous to Murphy is the duty assignment sheet, which I gather was furnished, but may not be. But would you say it's not the written operations plan?
It's part of the written operations plan. I would suggest to you that the piece of paper that talks about where the conage and the signs go, that's part of the written operations plan. I would suggest to you that the duty assignment sheet is part of the written operations plan, and I would suggest to you that 10 DFS 35 is also part of the written operations plan. It all compromises this broad term of written operations plan. And so when Detective Hughes testified as to this packet, and he looked through it, and he said, yes, these are all the documents that control this particular roadblock. He was talking about 10 DFS 35. He was talking about the duty assignment sheet. He was talking about the piece of paper that lays out specifically where all the cones go, where all the troopers are to stand, all of those things. And not all of those things were gone over verbatim with every single trooper the night of the roadblock. The only thing that was gone over verbatim was TRF 15. And I would suggest to you that's not the standard. The standard is not whether or not each trooper was shown each piece of paper. The standard is whether or not there was a plan and whether or not that plan was strictly followed. And I would suggest to you that 10 DFS 35 was part of the written operations plan, as that term is broadly described. And in Murphy, it's talking about separate documents. Those documents were not listed specifically as part of a written operations plan. It didn't say this letter is part of the plan, this letter is part of the plan. It's the same documents here as in Murphy.
Ms. King, we'll have to leave it there.
Thank you very much, Your Honors.